Welcome to Ask An Atheist. I'm Rebecca Markert, the legal director at the Freedom from Religion Foundation.
And I'm Liz Cavell, Associate Counsel for the Freedom from Religion Foundation.
Today we're going to talk about a new campaign that FFRF has undertaken in light of the coach prayer decision handed down by the Supreme Court back in June. And we're going to introduce you to a new member of FFRF's legal team, Sammy Lawrence. Liz and Sammy were the primary architects of FFRF's Know Your Rights campaign. So I'll be asking them both to tell us more about this campaign, how it started, what we're seeking to do, and overall what public school students can do to be free from religious influence and indoctrination by their teachers and coaches in their schools.
So as always, if you have questions for today, please feel free to submit them right on the Facebook page comments, or you can email askanatheist@ffrf.org.
So before we get started with our topic, this is Sammy's first appearance on Ask an Atheist, so welcome to the show.
Thank you for having me.
So our legal fellowship program is relatively new. We've only had it for probably 5, maybe 7 years. And the goal of the program is to bring in recently graduated law students to come and work for the foundation for a period of 2 years and really get their feet wet in state church law before they go on to do bigger and better things like becoming judges and running for office and things like that, and really having this background in their experience. So why don't you tell us a little bit about yourself, Sammy, and what drew you to work for the Freedom from Religion Foundation?
Well, I graduated from the University of Wisconsin Law School this past May, and during law school, I interned for FFRF twice and started working here in June. I've been passionate about the First Amendment for many years since high school, especially witnessing teachers in my public schools saying things that were deeply inappropriate and inserting their own religious beliefs into the classroom unnecessarily. And that really sparked my interest in the First Amendment and the separation of state and church. So I'm really excited to be continuing this work after law school and working with the Constitution to help defend that wall.
And it is pretty rare that a newly graduated law student, new lawyer, gets to work on constitutional issues. So we're really excited to have Sammy join us as part of our team. So let's get into our topic. Liz, you and I have talked a lot about the Kennedy versus Bremerton decision, a lot on this show, and our viewers may have heard us talk about it ad nauseum, not only on this Facebook Live program, but on our podcast. Liz and I host a podcast called We Dissent. It is a monthly podcast with four secular women four secular women attorneys from the 3 major secular organizations in the United States. And we devoted at least 2 episodes on the podcast to the Kennedy versus Bremerton decision. So even though we've talked about it for a long time, there are still people who are probably not as intimately familiar with it as we are. So why don't you tell our viewers a little bit about the background of that case and where we're at today?
Sure. So, if you might remember that the Supreme Court in this most recent term, where it did many other things that may have got your attention, like overturned Roe versus Wade, it also ruled on a couple of big cases that implicated the separation of church and state. And one of those was this Coach Kennedy versus Bremerton School District case. It involved a coach who insisted on praying at the 50-yard line after games, made a huge spectacle of himself, would pray with students from both his team and the opposing teams. And after complaints from parents in the district and parents on opposing teams, the school district told him that, as is and was the law of the land, public school coaches could not lead prayers or pray with students while they're coaching public school teams. So the school told him he'd have to stop, that he could pray privately on his own, in his own sort of silent way, not involving students. But he refused. And so sort of the school district and Coach Kennedy were kind of entangled in an employment skirmish, like trying to figure out what's a way that he could pray privately and still not subject the district to liability because he's acting on their behalf and he's promoting religion. So it became clear that Coach Kennedy was pretty interested in like martyring himself as a persecuted Christian. So he sort of was placed on leave while they figured this out and then opted not to reapply once his contract was up, and instead sued the school district for what he called discriminating against him in this employment kind of action. He wasn't fired. He wasn't terminated. He did not reapply when his contract was up after all of this ensued. So he took his case all the way up to the Supreme Court. He lost at every level because, of course, the district, under prior Supreme Court cases and the separation of church and state as it's been known by courts for the past like 50 years, the coach was not allowed to pray in his official capacity. The district was well within their rights to ask him to stop and to protect their own interests in not being sued. But then he got the Supreme Court to take up his case. And the Supreme Court did some interesting acrobatics and ignoring of facts and law and case precedent, as it has done in several other cases, and found in his favor. And so that has really shaken up the foundations that we and everyone in public schools have relied on for decades, establishing what the boundaries are in our public schools when our public school officials are interacting with students. You are being very kind when you say they engaged in a little acrobatics, because I think a lot of people think that what they actually did was gaslight the American public on what the facts were. We had showed, while you were talking, some of the pictures of what it looked like. He was calling it a private and personal prayer, but you guys all just saw those pictures where it was not private and personal, and it was on the 50-yard line. Right.
But one of the other parts, and then I guess I should also mention the Ninth Circuit, which ruled against Coach Kennedy, called his spinning of the facts a deceitful narrative, which, was another reason why it was so appalling that the Supreme Court adopted his version of the situation. And one of the other aspects of his deceitful narrative was that he no longer lives in Washington State. He moved to the state of Florida during the course of litigation, but told everyone that he would move back to the state of Washington for his job if he won. So he won, right. At the Supreme Court. And is he back in Washington?
No. So interestingly, he has yet to, so it is September something, 20 something. It's September 21st. Thank you. And school is well underway, as is the football season at Bremerton High School. Coach Kennedy is nowhere to be found. The Seattle Times actually recently ran an article just about the fact that the school district basically was ordered to reinstate him in his coach position, because this is one of the many things that's messed up about this case was that, just Court 101 is that you have to have an injury for the court to hear your case. And one of the many things that people were clamoring in this case was the Supreme Court to recognize that the case is actually moot, because the coach now lives in the state of Florida. This happened in the state of Washington. And so there's not a realistic possibility of him being reinstated as coach. He's not realistically seeking that position because he doesn't live there anymore. And therefore, the court cannot take an action that he's asking for, which is give me my job back. But of course, the Supreme Court wasn't moved by that. They ordered the Bremerton School District to reinstate him as coach. The school district, following the court's orders, is doing that by saying, here's all the paperwork, fill it out, background check, all that kind of thing. And a quote here from the school's spokesperson, Karen Bevers, says he's had the paperwork for reinstatement since August 8th. We haven't gotten so much as a phone call. In other words, he is not in any way pursuing returning as the coach of the Bremerton High School football team, even though he's out there on the persecuted evangelical Christian celebrity circuit, spinning his narrative and talking about, how precious his job as a coach was until he was discriminated against for his prayer. So we think this is a really good illustration for how unbelievably just neglectful of the most important part of this whole case he has been and the courts have been, which are the students, right? Like the students' rights, the students' experience, the obligation that we all have to students in public schools has been totally lost, both in the way the Supreme Court treated this case and Coach Kennedy and his conduct. As much as part of his personal biography is like how much he was moved to coach these kids, his actions since the case have shown that he could care less about the team, the students, and his obligation to them.
And of course, we talked about that in our brief, and we said that he wasn't going to do what he said he was going to do. He was not going to move back to Washington for this gig, which was only a $5,000 job, a $5,000 a year job. But nevertheless, the Supreme Court ruled in his favor, and now FFRF is working to remind students, the group of people whose religious liberty rights were actually lost in the narrative of this case, that they still do have rights in the public schools. There are going to be a lot of questions about what this case means for religion in the public schools, and we are certainly going to be seeing emboldened teachers and coaches pushing the parameters of this decision, if not crossing the line intentionally. So, Liz, why don't you tell us a little bit about the efforts that we've undertaken with the Know Your Rights campaign and why it's so important?
Yeah, so FFRF wants to just push front and center the most important thing about state-church separation in the public schools, and that's protecting students. And so, in that spirit, we are kind of rolling out a few different efforts. So one big one is this week going up in Bremerton, Washington, kind of right around the corner from Bremerton High School, is a billboard directed at the students, wishing everyone in Bremerton High School a safe, secular, and successful school year, and also putting the URL for our Know Your Rights page on the billboard so that students know where to go to read about what the case opinion means for their rights in public schools. So when you go to that URL, you'll find our digital brochure and non-prayer card version, kind of like a mini wallet card version of our Know Your Rights page, and all these resources for students to just explain in plain language what you still have the right to do and to be free from in your public school. And then another big component is that we have some of our attorneys have been working on a letter that is kind of a short memo to go to public school administrators in some target school districts around the country to try and proactively educate them about what this opinion did and didn't change and what their obligations still are to their students, to really try and make sure that this opinion doesn't lead to just chaos and a lot of unnecessary violating of students' rights by public school administrators who are confused or misinformed. And then we're going to be promoting on social media as much as we can, both all of our campaign resources, and trying to kind of keep in the conversation some perspectives from former students, former coaches, so that we're talking about and moving the conversation back to what the harm is when religion and public schools are mixed. And so this is one graphic that we've made, and this is the type of thing that we want to put in the conversation, which is a quote from a former NFL player, Robert Turner II. "If you please the coach, you will play." And that's meant to sort of capture what we all know, which is the student-coach relationship is inherently coercive. The power dynamic is such that coaches and teachers, but there's something unique about sports. Coaches have so much immense power and authority over the students that play for them because they control their futures. They control their playing time. They control whether or not they're on the team. They control what types of opportunities they have for athletics in college. And so the relationship is inherently coercive. And that's what is totally lost on the Supreme Court and Coach Kennedy. And so we want to kind of keep that perspective in the conversation. And that's why public school coaches and teachers should not in any way promote religion when they are acting or favor religion when they're acting in that role, because students, like it says, like the former NFL player is saying, anybody that's played on a sports team knows if the coach does something or says something, you do it, even if it's not required. It's like there's going to be an extra optional weight training this morning, and there's going to be, we're all going to go to lunch as a team. Like, you do what the team does and you do what your coach wants, because that is the power dynamic. And so that is why it is so important that coaches are not abusing that power to push religion on other people's kids, the students that are playing for them or under their care as teachers.
And that was the interesting thing, I think, in the aftermath of this case, was that there were so many former athletes and even professional athletes who took to social media to say, I remember when I was a student player and I had to participate in prayers and things like that. Like, they all seem to also understand that this is a problem and it is a coercive environment, the things that you're talking about. I think even Kareem Abdul-Jabbar was talking about how this was a bad decision. So there was a wide variety of people who were coming out condemning this decision because they knew what it was like to be that student who was forced to do things that they might not believe in, right, as students. So let's talk about the rights, though, that students still have. There were atheist players on the Bremerton team who complained and said that they felt that they had to go along with the prayer because, they were part of the team and they wanted to play. So, Sammy, why don't you start us off? We want to kind of go through all of the rights that we list on our brochure. So why don't you tell us what rights, what is the first right that students still retain in public schools?
Well, to begin with, students still have the right to be free from teacher and coach prayer. Teachers and coaches cannot force students to pray, can't lead them in prayer, can't force them to participate in any kind of religious exercise. That's right.
So what the court was saying was that Kennedy's prayer was personal and private. So they can't, have speaker or loud, let me start again. They can't have prayer over the loudspeaker, and they can't be like, hey, everybody, we're going to go, do the Lord's Prayer before math class or anything like that. That's what you're saying, right?
Yeah.
Yeah, and you might be thinking, wait, that's exactly what those pictures showed that you just showed on your program. I don't understand what's going on. And you are right, and you are not crazy, but you are being gaslighted by the United States Supreme Court, because even though that was what was going on in the Kennedy case, that is not what the court acknowledged was going on. And so that is not what the court's opinion approves of. What the court's opinion approves of is a private, personal prayer that the coach is engaging in his sort of downtime that is kind of shouldering all of his official duties while he's acting as a coach. That wasn't truly what went on in the case at issue, but that is the extent of what the opinion condones. And so students still have the right to participate in public school athletics without these official team prayers or the coach even just gathering the team for prayer, leading the team in prayer, and all that stuff that Sammy just explained.
And so, Liz, what is the second right that they still retain?
Yeah, so another big thing is students still have the right to secular school events. That means official school-sponsored events, which is everything that you would naturally think it is, like graduation ceremonies, high school or school sporting events, awards banquets, sports banquets, that type of thing. Those events have to be secular. They can't open with a prayer or close with a prayer. They can't have prayer as part of the agenda or the ceremony. So those events are supposed to be welcoming and open to all students, and the price of participating in those events cannot be submitting to some religious ritual that you may or may not believe in. So the court's opinion did not do anything to change that.
Right. We are also focusing a lot on football because that was what the Bremerton case was, but we have seen prayer in a lot of other contexts as well. We've seen it as part of baseball games and basketball games and soccer games and swim team. And, you know, I've been here for 14 years, so I feel like we've seen it all. What's the next right, Sammy?
The next big right is students have the right to be free from bullying or harassment by teachers or coaches for having a dissenting viewpoint, for being part of a minority religion or non-religious. They have the right to be free from teachers making snide remarks or coaches making an example out of them because they wouldn't participate in a team prayer.
Yeah, and this sometimes comes up, like Sammy mentioned, teachers making snide remarks, and sometimes it's a little more subtle, like just being singled out by a teacher or a coach. One interesting kind of overlapping free speech issue that we see with this that comes up is when students don't want to participate in the Pledge of Allegiance. You have the right to hold a dissenting viewpoint. And that might be for religious reasons because our pledge is unnecessarily religiously, it's a statement of religious belief because it includes God belief. But of course, we see protests against the pledge for other legitimate reasons, and those viewpoints are protected. And we see teachers often singling out students who hold those viewpoints and who, abstain from participating in the pledge, as is their right, being totally embarrassed and called out and shamed by their teachers or coaches for doing that. And it's your right to do that without being bullied or harassed by your teachers or coaches.
Well, and sometimes it isn't so subtle either. I remember a case where we had a complaint from a student whose math teacher stuck a Bible underneath his chair while he was taking a test. And when he was finished with the test and left class, he looked at the Bible and it was inscribed to him. And she obviously knew that he was non-religious. And she had just noted some particular Bible verses that he might be interested in reading. So, that's sort of a little harassing while you're taking a test to get a gift in that manner from your teacher.
Right. That is religious harassment. That is not what that teacher meant by it. But if you are the parent of a student who does not subscribe to that religion, is non-Christian, that is absolutely harassment. And it's not legal.
Right. So the next one, Sammy.
The next one is you have the right to be free from coercion. No one, teachers, coaches, any public school employee can coerce you to believe in any religion, to participate in any religious exercise, to participate in a prayer. And coercion can be both direct and indirect coercion as well.
Right. That's such a good point, Sammy, because that gets to what we were talking about earlier about the student-coach relationship and the power dynamics at play. And this goes for teachers too, because teachers hold immense power over students as well. They control their grades, which controls their college prospects, and they control, whether or not they're in trouble, whether they have disciplinary records. They control a lot of a student's life and future. And so indirect coercion can happen and happens and is at play all of the time in classrooms and on sports teams, because when the coach says do something, you do it. And it doesn't matter if, you're coerced in a direct way, meaning do this or you're off the team, or if the coach is just saying, we're all going to do this, right? Like there's, I guess, a difference between those things, but in the relationship that is so inherently coercive and where the power is so imbalanced, there's a lot of indirect coercion being brought to bear on students in those situations.
And that precedent from the Supreme Court about coercion, particularly in a public school context, that still stands after Kennedy, doesn't it?
Right, that's right. So again, the Supreme Court found that what took place in Kennedy's case was him engaging in a private personal prayer. And they were saying that the district's conduct in telling him that he couldn't do that and ultimately placing him on leave while they sorted that out violated his rights, his free exercise rights and his religious rights. They did not say that he had a right to engage in that type of coercive practice that you saw the picture of, gathering everyone around and saying this is what the team is doing. And that has long been held unconstitutional under the Establishment Clause, and that is still the law of the land under the Kennedy case.
And there's a couple of more rights that we're going to go through. Sammy, why don't you give us another one?
Another right is students have the right to freedom of conscience. They have the right to hold any viewpoint that they want, religious or non-religious, without interference from their public school, whether that be teachers or coaches.
That's right. And that that's where the overlap, we talked about the Pledge of Allegiance thing and the right to speech, the right to hold dissenting views, and all of that is sort of embodied in this right to freedom of conscience. And that is what the First Amendment is meant to protect in all of its clauses, is this right of freedom of conscience. And in the public school context, that's a right that belongs to the students, and that's what should be guarded by these school districts as they figure out how to go forward under this case. And
so basic
it's
and
so
essential to our founding principles.
Right.
So still hasn't been taken away.
Yes, we're hanging on. So, and last but not least, we wanted to mention, and this is the last thing in our brochure, which is students, you always have the right to complain, to speak up, to report violations if you think they're happening in your school. And you can always do that at ffrf.org because we will always take reports and keep them anonymous and try to help resolve issues that are going on in public school districts on behalf of students.
And these reports are handled in large part by our intake team, of which Sammy is a part. So a large part of your job is responding to these complaints and writing to government officials when we get violations. It's a pretty robust part of FFRF's work is to stop violations short of going to court, because a lot of times we can stop these violations and the school districts will do the right thing when we point out. They also have a duty to their student body, to protect them. And so they don't want to have proselytizing coaches and teachers either.
Right.
We have a lot of questions.
We do?
So we do. We have a lot of questions. So let me... I am surprised. So let's get to it. So the first one is from Patrick N. How do you see the role of lawyers in cases where courts are willing, as the Supreme Court was in Bremerton, to deploy alternative facts? And how do we litigate in a post-facts world?
That is such a good, hard question. To be candid, that is really what we're all grappling with in the wake of this Supreme Court term. And it's not just our cases. This is happening in other cases as well, where we really, truly do have an activist court that is ends-driven. And it is very hard to litigate in that world. But, of course, we and everyone else are strategizing how to go forward in litigation. All of the coalition groups that work on state church issues are talking to each other about how to go forward in the cases that we already have going on and how to take cases strategically so that we can still make an impact in the federal courts. But it's hard.
Well, and also I will just say that one big way that we can combat this is through court reform, and really not only just adding seats to the U.S. Supreme Court, but adding federal judges overall. That's really, in my view, the only way we are going to make any progress in this situation, because the Trump administration stacked the courts so much in favor of religion. So even when we find these perfect cases and things like that, it's going to be really hard to litigate them. And so Liz is absolutely right. We are grappling with this, trying to figure out how do we play this game when the rules have changed so dramatically over the last 2 years. And actually, there's a really good article, I think that I forwarded it to everybody on our staff, but by Dahlia Lithwick and Mark Joseph Stern in Slate, where they were talking about how it's really hard to be a lawyer these days because you don't know how to litigate cases. And the only thing that we can do right now is everybody should be pushing for court reform and paying attention to what they want in a judge and who they want on the bench.
Right. And that's such a good point, and it's 100% right. And as that article Rebecca referenced points out, it's like, excuse me, it's like, it has to be acknowledged that what's going on in the court, just completely ignoring facts. Like, you all saw those photos. Justice Sotomayor had to put photos in her opinion because of this phenomenon. Like, these are pictures of what happened. This is what the Supreme Court held happened. Something is amiss. And it's just something that we as lawyers have to come to the point at which we say, and Rebecca and I are already there, and this is what Dahlia Lithwick was arguing in that article, is not okay. It's not okay. It's not normal. It's not a normal, sometimes cases go your way and sometimes they don't. This is not normal. This is actually really corrupt and broken, and it's because of the way that the courts have been stacked exactly to affect, these political goals. And we have to embrace court reform as a check on a judiciary that is completely out of control. It's not playing by rules anymore. So it doesn't work if we all aren't playing the same game.
Right. So the next question is from Bridget R. I just want to know if and when other kids or teachers of other religions start praying at school events in the way of their beliefs, will they be protected too? I feel like we are all being held hostage to beliefs that are not the same for all of us.
Do you think they're referring to non-Christian versions of...
I believe
right.
That's what she was getting at.
Yeah, I mean, that's the problem with a court that is inverting the entire purpose of constitutional rights, right? Like, the whole purpose of the Bill of Rights is to protect the minority from, like, majoritarian religious views being pressed on everybody by the government. So this is the problem. It's always, not always, not exclusively, but almost always, we hear thousands of these reports every year. It's Christianity that's being pushed by teachers and coaches by and large, not exclusively, but a very large percentage of what's going on in public schools being pressed on students is Christian evangelism. And that's what makes it so insidious. It's that the most of the students in the class also are of that belief system, so that the one or two students who might be atheists or Muslim or Jewish or just non-Christian have so much pressure being placed on them to conform that it's just absolutely wrong. It's just the power of the majoritarian force of government and a majority viewpoint all being brought to bear on minority kids, students. So you're absolutely right. It gets people's attention when this is done from another faith viewpoint. We try to illustrate that with atheist viewpoints, like try to show Christian teachers and coaches and administrators, well, think about how you would feel or how you would feel about parents feeling if this were a Muslim prayer or if this were an atheist viewpoint being pressed on students, Christian students, right? Like, people understand that that's wrong. So it's hard, but you won't see that because that's not how majoritarian and minoritarian forces work.
Right. Well, I was going to ask Sammy, you're part of the intake team. You've been here since June. How many of these minority faith complaints have you gotten?
Since June, zero. When I was an intern, I remember exactly one complaint that was a weird Jewish group partnering with a fundamentalist Christian group. So that was technically partially minority. But since June, I have had zero. They've all uniformly been Christian.
Yeah.
Right. Because it's a majority religion in our country, and that's how it works. That is why this is able to take hold, and that is why we need the First Amendment to protect the rights of the rest. That's fine that Christianity is the majority viewpoint. What's not fine is that, Christians can use the power of public schools, which is government, to convert all the rest of our children to that viewpoint, when that's not our family's faith.
And I remember being asked after this decision came down, well, of course, everybody would be okay with a Muslim bringing out a prayer rug on the 50-yard line and praying to Mecca. And I think that we have to be honest about the fact that that case would have never made its way to the Supreme Court. The school district would have shut that down, and nobody would have complained about that. Nobody would have sued. Everybody would have agreed that the school district was in the right to not allow something like that. And that there are Christian litigants right now that have a preferred status at the court and in our court system.
Exactly. Again, which is not okay and not fair and not the way that it's supposed to work.
Right. So another question, James R. asks, how narrow or broad was this ruling? Is it specific to the Bremerton situation, or can it be used more widely in any school situation?
So I think it's narrow in the way that Rebecca was explaining, which is the court held that Coach Kennedy was engaging in a personal and private prayer on the 50-yard line, which is a stage. It's very hard to parse, but the court held that specifically Coach Kennedy's conduct, which it found to be personal and private, was protected under the Free Exercise Clause, and that the school couldn't stop him from doing that. It did not address the reality of the situation, which was actually leading students in group prayer. It put its head in the sand and pretended that that was not what was going on. So it's narrow in the sense that, like we've been saying this whole program, those things and those rules that have been held over decades are still the law of the land. The problem, the broadness is that it signals, and it is a further kind of proof point in this just march of this court towards this future where Christians are just a preferred class of Americans and everyone else are second-class citizens, and we are all subject to sort of discrimination and anything else that, Christian citizens want to engage in without any protection from our Bill of Rights or our anti-discrimination laws or anything else, because this court is always going to rule in favor of those litigants. And that is what it's doing here, in, bending over backwards and turning inside out and lying in this case in order to do. And so the court is telling us we will always find for these types of litigants. And that is the part that is broad and can be used and will continue to be pushed and exploited further and further and further by litigants like Coach Kennedy, who is, the reason he's not turning in his employment paperwork and showing up for practice at the Bremerton High School is because he is out cruising around the country, doing speaking engagements, like cashing checks, raising money, being a professional, political, persecuted Christian. That is what this is all about, and that is what this court is here for. And that is the part that is scary and broad and will continue to be pushed and pushed and pushed.
One of the big concerns that we had after this decision came down is that it was going to be seen as a green light to a lot of school districts, that they could allow coaches to pray at the 50-yard line or with students and things like that. The school year is just underway. Are you seeing anything like this, Sammy, that's coming in through intake?
Yeah, I believe that across the board we have seen an uptick in coach prayer. We've also seen an uptick, or at least I have, in just prayer suddenly being a part of school board meetings when it previously wasn't. I got several complaints in July and August of school boards suddenly having Christian invocations as part of the beginning of their meetings. And of course, there's no reason that they have to do that, but they feel emboldened to do it. Also, prayers as part of teacher in-service training for the beginning of the school year. I've gotten a ton of those. Some districts having never done it before, or having done it in the past, and now the responses are, well, the Supreme Court said that this was fine.
So what do we do in those situations? How do we fight back?
Well, Sammy?
Well, if the district is clearly uninterested in listening to us, one thing that I have been encouraging our complainants to do is if they feel comfortable speaking out themselves, because I think sometimes districts get a letter from us and they think, oh, this is just some random group in Wisconsin complaining. But if they're hearing it from people who are directly a part of their community, whether it's students, teachers, parents, it really brings it home and might make them realize, like, hey, what we're doing here is really offensive and alienating and just unnecessarily divisive, and it's really hurting our students and community more than it's helping anybody.
Right on. And I mean, to bring it full circle, a big part of our Know Your Rights campaign is about bringing that perspective that Sammy is describing into the conversation. Okay, Sammy's teams and intake are trying to make that argument directly to school districts, and we also are trying to put that perspective out into the world to try and get this perspective into the conversation. Like, this is harmful to students. This is something that, whether the Supreme Court thinks that this is a constitutional principle that's worth being protected or not, this is something that, like, we as a society shouldn't want to be a part of our public schools and shouldn't want to be dividing and alienating our public school students when they go to school. Like, we should want our public schools to be open, welcoming, places where kids can get an education without, being divided along religious lines or having it be this huge religious battleground where, they all have to kind of defend their points of view or just feel totally isolated if they're in a minority. So
kind of along these same lines, Tim W. asks, is there any recourse now? In other words, can this case or a similar one be brought up again where it perhaps gets Kennedy overturned?
Well, we look towards a future where the American people, demand court reform and demand to have courts that are actually fair. And that doesn't mean courts that always decide what we want them to decide. It means courts that are actually fair, not corrupt, and not total shills for one side of every single case. And that's what we have now. And that's not hyperbole or anything radical. That's what we see happening in case after case after case. So I think long term, we hope for a future where we have a more rational, fair, and, individual rights focused Supreme Court and just federal courts more broadly. I think in the short term, you're probably going to see, in the courts at least, the opposite, which is bad actors using these cases to push further and further on these fault lines, like trying to get more and more conduct like what Coach Kennedy was doing approved by the Supreme Court. And we have cases up before the Supreme Court this coming term seeking to get the Supreme Court to give their stamp of approval to businesses discriminating against, again, this old song, gay spouses that are trying to get married and obtain wedding services. We have the Supreme Court ready to weigh in on a case being brought by a website designer that wants the court to say they don't have to obey anti-discrimination laws because they want to advertise that they discriminate against gay couples. And the Supreme Court has taken that case, which means they want to say something on that topic. And so that's not good. I mean, the Supreme Court is not done pushing this agenda farther and farther and farther. So I think in the short term, we have to keep beating this drum, educating the public about why this is so important, what rights we still have, what rights we should demand, what we should expect from our federal courts. And, we have to save our Bill of Rights.
And I think it's so important to be the dissenters at this time. Just as lawyers, the job of being the dissenting voice and putting out the dissenting argument is really laying bricks for future generations to overturn these cases and giving them the groundwork on how they can do that and how we can shape the law. But in the present, it's also very important to be the dissenter because it does shape the way that these cases are talked about in the public and in the media, and you never really know who you are going to be reaching. Somebody who never thought about it in the way that you're thinking about it. And I really I think it's the ACLU that has to dissent is patriotism. It's just a very big American principle that we should all be proud of. And I really believe that. I mean, obviously, we called our podcast We Dissent, not just because of the situation that we're currently in as lawyers working for a state-church separation, but also because I really do think that having this opposing view and really standing up for people when things look so grim and there's so many injustices going on is so incredibly important. And I also really look to the future. I mean, we have demographics that are in our favor and a generation that is very activist and very inclusive and very engaged. And so I'm very excited to see where these students that we're educating right now through this Know Your Rights campaign are going to take this.
Right.
All right. Well, so that's it then for this week's Ask an Atheist.
And you mentioned it again, Rebecca, but before we go, we have to shamelessly plug our newest podcast. It's We Dissent. New episodes drop monthly wherever you get your podcasts. You can go to we-dissent.org to find out more. And also this week on FFRF's television program, it's Free Thought Matters. Annie Laurie Gaylor and Dan Barker speak with Rhonda Black, a Central Florida actress and freethinker who is at the forefront of giving non-religious invocations at government meetings. Check out this preview.
I don't really need a God to tell me to be nice to my neighbors. I don't need a God, lowercase g. I don't need a higher power to tell me to do a good thing. I just do it naturally. I don't need someone or another entity to tell me not to kill somebody. That's just innate in who we are.
You can watch Free Thought Matters on TV stations around the U.S. on Sunday mornings, or you can stream it on our Facebook and YouTube channels.
And this week on Free Thought Radio, Dan and Annie Laurie observe Banned Books Week by talking to writer Marty Essen, who details the links between Christian nationalism and book bans across the country. Go to ffrf.org/radio to learn where you can listen or find it on your favorite podcast app. If you want more information about the Freedom from Religion Foundation, please check out our website at ffrf.org. Thanks so much for watching Ask an Atheist.